All right. Hello, everybody. My name is TJ Scott or Timothy Scott, and I am the owner of the law office of Timothy J. Scott. I'm an estate planning attorney, and what that means is that I help people avoid court and conflict in their family after something happens to them, meaning either incapacity or death. And I have to say, I am so happy to have you here with me today. Today, we're going to be talking about something that I know is a difficult topic. It's hard to talk about incapacity. It's hard to talk about a time when we might not be functioning optimally, or we might be gone and our family is dealing with the loss of us and dealing with the fact that we're no longer there to provide them support. And I know that this is difficult, but I also believe that knowledge is power. And that's what I really want to do here today. I want to empower you and educate you so that you can have some peace of mind around this important issue. And so today I have some really valuable information to share with you. I also have some valuable offers that I'm going to be making right near the end of this presentation. And so I hope that you'll stick with me. I hope that you'll stay with me and learn this information all the way through to the end so that you can hear those offers and you can hear about how you can get a great estate plan in place for your family that's going to take care of them when you can't be there to take care of them. The best way to learn here with me today is to be present with me. You signed up for this class. You signed up for this free class so that you could learn this information and internalize it and use it for yourself and use it for your family. And so I just want to encourage you to be here with me, turn off distractions. You've set this time aside. Give yourself this time to be with me and to learn about this topic. And I always say your future self is really going to thank you for being here, being present with me, and learning this information with me right now. And again, if you stick around until the end, I have some really valuable offers that I think you're going to enjoy. I think that I hope that you'll take advantage of. The first offer that I have for you is how you can get a free virtual one-on-one meeting with me to talk about the things you have and the people that you love and how you can protect them. And the second offer that I have is a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place for the people that you love. And so stick with me to get some details about exactly how that's going to work. I'm just going to check one thing here as we continue to see people trying to file in that everything is set up correctly. Perfect. Yes. Good. Okay. So the first question that I have for everybody here today is, do you have an estate plan in place? And an estate plan means a whole collection of things. And so oftentimes I'll have people come to me and ask me, do I need to have a will? Do I need to have a trust? I have a will, so I have an estate plan in place, right? I'm covered. Or, I've put beneficiary designations on my accounts, so I've got everything taken care of, don't I? But really, an estate plan is a lot more than the individual pieces. An estate plan will often include a trust, a will, a guardianship nomination if you have minor kids, a healthcare directive, somebody who can make healthcare decisions for you and what kind of healthcare decisions you want made on your behalf, a power of attorney, which is who can make financial decisions for you and what kind of financial decisions they can make for you. If you become incapacitated, generally, it's if you become incapacitated, as well as beneficiary designations on your accounts. And all of that is fantastic. But it really covers your body during incapacity and your assets. It doesn't necessarily reach beyond that. It doesn't necessarily reach to helping your assets to escape from the state departments of unclaimed property, which is something that I'm going to talk about here in a little bit. And it doesn't necessarily reach to passing down your values and your stories, which are so important to so many people, but can be lost if you don't have a way to capture those assets and make sure that they're passed down. Those intangible assets that aren't physical, but that we often want to share with the people that come behind us or come after us. And if you don't have an estate plan in place, I don't want you to worry or feel like you're out of place here, because you're not alone. In fact, something like 69% of Americans currently do not have an estate plan in place. And there can be a lot of reasons for that. Maybe you feel like you are too busy And I totally get that as a father of 3 small kids. I totally get feeling too busy a lot of the time. Life in America is really busy. And so I totally get that. But if that's the case, I really want to commend you for taking the time and being here with me today and educating yourself about this topic. And this is the first step on your path to getting an estate plan done. And so I really want to commend you and congratulate you for being here with me today. And I want to make it easier for you to take the next step so that you're able to get an estate plan in place. And maybe you feel like you're too young. You don't have an estate plan in place. You don't feel like maybe you need one because you're too young. And anyone over the age of 18 really should have an estate plan in place. And I recently helped a young family where a young father had passed away and he didn't have an estate plan in place. Unfortunately, he left something of a mess for his young daughters, his minor daughters, and his young wife. But that doesn't have to be the case. Anyone over the age of 18 really can get some great foundational estate planning documents in place, which will help if anything happens to you. And especially, if you're in that 18 to 22 range where you're in college, if something happened to you, you would want your parents to be able to make decisions for you. At least a lot of college students would. They'd want their parents to have access to their healthcare information. They would want their parents to be able to access their accounts and pay rent if they needed to pay rent and do that kind of thing. But if you don't have some of those foundational estate planning documents in place, that's just not possible. Once you turn 18, you are out on your own, and there are processes that your parents would have to go through. There are processes that any parent would have to go through in order to get access to make those decisions. Maybe you're worried about an estate plan being too expensive, and I completely get that. As somebody who's cost conscious myself, I understand that, and I'm going to speak directly to that point today. I'm going to speak to what you can expect to pay for an estate plan that's really going to take care of the people that you love. And so I will be speaking to that today. And again, I have some offers that I'm going to make at the end that are going to make it even more affordable to get an estate plan in place and make sure that your family is well taken care of. Maybe you're worried about jinxing yourself. And this is something that I've heard from a lot of people, but I want to put your mind at ease. I have done dozens of estate plans, and I've never seen a correlation between getting an estate plan done and having something happen to one of my clients. In fact, I always say, I think that my clients tend to live more intentionally because they get an estate plan done, and they tend to get more out of their life. They tend to have more enjoyment out of their life because it's no longer a weight that's sitting on their shoulders. And maybe you've come here and you already have a plan in place. And if that's the case, great. I'm curious if anybody has a plan in place. If you want to post in the chat what it is that you're hoping to learn here today, I'd really appreciate seeing that. And maybe your question is that you've done an online will or some kind of do-it-yourself back of the book will, and you want to know if that will is going to be enough of an estate plan to take care of the people that you love. Maybe your estate plan is old and you haven't looked at it in a while, and you want to know if it's outdated, if certain changes in your family might have an effect on that plan. And what that effect might be, and if it's something that you need to update. Or maybe you want to know if maybe the attorney that you worked with in doing your old estate plan didn't really bring you along on the way that he or she was drafting that estate plan. And so you don't have a great understanding of exactly what the documents say and what they mean, and you want a better understanding of what those documents are and what they say. If any of those things resonate with you, again, I hope that you'll post in the chat so that I can see that. And if you have any specific questions that I can answer today, I hope that you'll post them either in the Q&A where it says Q&A or in the chat box, and I can answer those questions for you. Whatever the case, if you have an estate plan in place, if you don't have an estate plan in place, if you are hoping to learn, if you're worried about how expensive this is going to be, if you're worried about finding the time to get this done, whatever your worries, whatever your concerns, I want you to know that you're in the right place here with me today. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, but you're not sure if it's going to work and take care of your family in the way that you wanted to. And you're in the right place if you're nervous about how much this is going to cost. Again, I'm going to talk about that directly here in this webinar. But the reality is, estate planning isn't about you. It's really about the people that you love. And pictured here on the screen are my three kids. From left to right, it's Margaret, Ben, and Elizabeth. Margaret is our 4-year-old, Ben is 9, and Elizabeth is 6. And they're really my whole world. And I want to make sure that they're taken care of if something happens to me and if something happens to my wife. And so getting an estate plan in place for my wife and I was a non-negotiable, because we know that we want them to be well cared for if something happens to us. So here's what we're going to talk about today. Here's what we're going to cover. We're going to talk about planning for incapacity. And we're going to talk about who can make healthcare decisions for you and who can make financial decisions for you. And what does that process look like? We're also going to talk about planning for when you pass away. And that might mean planning for guardianship if you have minor kids. In fact, if you have minor kids, you really need to be planning for guardianship. But it could also mean planning for probate, which is a court process that comes after your death that your estate needs to go through. We're going to talk about probate. We're going to talk about the time, cost, and public nature of probate here today. We're going to talk about estate taxes. I know a lot of people are worried about estate taxes. They're worried about what the state is going to take out of their estate before it becomes their child's inheritance or their loved one's inheritance. We're going to talk about that today. And in fact, I think I probably have some good news for most people regarding estate taxes today. We're also going to talk about unclaimed property and how assets end up in state departments of unclaimed property and how you can avoid your assets ending up in the State Department of Unclaimed Property. We're also going to talk about intangible assets, things like your values, your stories, and how you can capture those and make sure that they go to the people that you love, the people coming after you. But before we talk about those things, I want to give you just a little insight into who I am and how I operate. So this is my family, and we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Elizabeth, this time from left to right, it's Elizabeth, again, she's 6, Margaret, she's 4, and Ben is 9. And my family is really my whole world. I graduated from the University of St. Thomas School of Law in 2012 near the top of my class. And the very next day, my first child, Ben, was born. After graduating, I found a job with a small estate planning law firm in Minneapolis, and I loved the clients that I was able to work with. But at the same time, I didn't always feel like we were providing the value that our clients deserved. And so after a little more than 3 years, I ended up leaving the law firm. And this is actually a picture from my last day there at the law firm. Someone has to graduate at the bottom of the class. Now, this was something that was not said about me. This was said about an extremely negative experience that my parents had in working with the estate planning attorney who helped my grandmother to plan her estate. And in particular, I remember my mom saying this: someone has to graduate at the bottom of the class about this attorney. And there was a big reason for that. They were underserved in the work that this estate planning attorney did. And they were underserved in the estate plan that had been written for my grandmother and the way that it ended up rippling out and causing issues in the family. But I don't actually think it was this attorney's knowledge or ability to learn or intelligence that caused this estate plan to fail our family so badly. In fact, I think they were practicing under a faulty model, a traditional model that many estate planning attorneys follow, but it's a model I call planning for death, because it really is not designed to take care of your family in the way that you would want them to be taken care of. And I'm going to talk a little bit more about that faulty model in a little bit, but first I want to talk about some of the aspects of planning. So guardianship is something that is really essential for anybody who has minor kids. And there are two sides to guardianship. There's short-term guardianship and long-term guardianship. So short-term guardianship is really, the way to think about it is, what happens if mom and dad don't show up? The kids are with a babysitter, they've gone out to a dinner, something like that, a date night, and for whatever reason, mom and dad don't show up. Well, if there's no plan in place, that babysitter is going to call the police, and the police are going to get child protective services involved, which probably isn't a good solution for those kids. I know I can tell you, I don't want my kids to spend any time with child protective services. And so we have planned for short-term guardianship. If my wife and I are on a date night and something doesn't happen, if we don't make it home, if something does happen and we don't make it home, then we have a plan. And we have people that we have given the legal authority to stay with our kids. And there's a way to do that. There's a way to create a short-term guardianship. And I make sure that I do this with all of my clients so that the kids are covered not just until they're 18, not just somebody to raise them until they're 18, but the kids are covered that very night when something happens so that they can be with family and they don't have to be with child protective services. Long-term guardianship is who is going to raise the kids until they're 18. And if you haven't made a nomination, if you haven't said, this is the person or this is the place that I think my kids would thrive, then there is a plan in place. And the plan is that a judge is going to decide what's in the judge's mind, what is in the best interest of the child. And unfortunately, it's probably a plan that you're not going to like, because you know your kids a lot better than the judge knows your kids. And you know where your kids are going to thrive and where they would do well. And it's really important that you make that nomination in a legal way so that it's enforceable and that a judge can rubber stamp that decision then down the road if something ever happened to you and your kids were in need of somebody to take care of them until they're 18. So now let's start talking about the assets and how people would receive assets under your current plan. And if you don't currently have an estate plan in place, or if your estate plan is based on a will, then there is a state estate plan written for you. It's a court process called probate. And I want to reemphasize the fact that this is the plan that's written for you if you don't have any estate plan in place, or if you have a will-based estate plan. That probate is a process that your estate is going to have to go through in order to get somebody in and able to operate on the assets that you have and make sure that those assets get to who you want to receive them, who they should be distributed to. And probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. It's a slow process. In Minnesota, it takes at least 6 months to get through the process of probate. More often, it takes something like 12 to 18 months. And the truth is that we'd like it to go faster, but it just can't. It just is a slow process that you have to go through. It's a one-size-fits-all process. And so there are slowdowns that are built in. There's bureaucracy that's built in order to ensure that everything is done in the proper way. Probate's also very costly. In Minnesota, we estimate that probate costs somewhere between 3 and 6% of the gross value of your estate. And there are all kinds of different fees that enter into it. There are attorney's fees, executor's fees, appraiser's fees, filing fees, bond premiums, personal representative, or I guess I have executor fee already on there. But all of these different fees weigh in and end up depleting a lot of the assets that are in the estate. And again, we estimate something like 3 to 6% is a pretty fair estimate of what probate generally costs in Minnesota. And we'll actually have a chance here in a little bit to calculate what that might mean for our own probate in particular. Probate's also public, and a lot of people don't know that, but in order to have your will enforced, you have to submit that will to the court, and the court makes that document public. And so that's how I'm able to access wills, including this will, which is the will of Anna Nicole Smith. And it's been a while since we've heard anything about her. Obviously, she passed away a while ago, so that's not terribly surprising. But what is surprising is the fact that we can access her will publicly, because that will had to be submitted to the probate court and the probate court had to make it public. And that means that we can go and we can see exactly who Anna Nicole Smith wanted to receive from her will and exactly what she had hoped to have happen at her death. So that's kind of a disturbing thought that that all of this has to be public, that all of this has to be made public as part of the probate process. And finally, minor kids, if you don't have a plan in place, or you don't have something called a testamentary trust, which is in your will, built into your will, or you don't have some sort of revocable trust in place, the default is that minor kids will receive assets at 18 and unprotected. And I think we all know stories about people receiving assets at too young of an age and how people can really be spoiled by receiving those assets at too young of an age and how harmful that can really be. And so this is something that I don't think anybody would want their kids receiving at too young of an age. And it is avoidable, but you've got to do some planning in order to make sure that it doesn't happen for your kids. All right, so here's our opportunity to calculate what probate might cost for your estate. And here you can see I have kind of an estimated or an example probatable estate. These are all assets that pass without beneficiary designation. And because they don't have a beneficiary designation attached to them, they need to pass through this probate process. And so I have things like a home, rental property, furniture, cars, stock bonds, bank accounts, and business interests. And so in order to calculate 5% of what your gross estate would be, you can do that really simply by just moving the comma over one place. So then you've got 85,000 instead of 850,000, and then dividing that number in half. And that's how I got to this $42,500. And that's an estimate within the 3 to 6% of the gross value of the estate that we estimate for probate in Minnesota. All right. Excuse me. All right. And I mentioned before that that we were calculating those assets because they don't have beneficiary designations on them. But if you have an asset with a beneficiary designation, and retirement accounts and life insurance proceeds often do, but that beneficiary designation is to a minor, and those assets also have to go through a process like probate or a process like conservatorship or guardianship of the assets that subjects those to additional costs similar to the probate process, if not the probate process. And so here you can see that all of a sudden the costs of probate have really skyrocketed because those assets were payable to a minor. And again, a minor can't receive those assets directly. They can receive them at 18, which is not desired, but in order to get them through the process, they have to go through a process like probate. There is a foolproof way to avoid probate. Probate is optional, but the foolproof way to avoid probate requires that you do some planning. It requires that you write a document called a living trust or a revocable trust. And what that is, it's an agreement, it's a contract that you write with yourself as the trustee, promising to control the assets as determined in the trust. And then the trust has instructions for how those assets should be used. And as the creator of the trust, you get to write exactly what those rules are. And that's a process that I bring my clients through, where we talk about what kind of different rules they want to have in place for if they're incapacitated, what kind of rules do they want to have in place when they pass away, and what do they want their trust to look like? What kind of rules do they want their trustee to follow? So you're the trustee, you're the creator of the trust as well. You're also, during your lifetime, the beneficiary of your trust. So you get to completely benefit from the trust. And because you're in all three of those roles, we call it a living trust or a revocable trust, because you can change anything at any time. You can take assets out, you can put assets in. You can also revoke, which means completely tear up and say, I no longer want my assets governed by this trust. Or you can amend the trust, which is just changing particular passages within the trust at any time. So you have that full ability to revoke and amend the trust. As long as you have capacity, as long as you have understanding of what you're doing, you can make changes to your trust at any time during your lifetime. But in order to have the trust govern over all of the assets that you have to make sure that all of your assets get into the trust. And so that means doing things like retitling investment accounts, things like brokerage accounts, or if you have stocks in a stock clearinghouse somewhere, signing new signature cards at the bank so that that bank account goes into the trust, executing deeds to real property. And that could be, oftentimes it's a quitclaim deed that will quitclaim a house or a cabin or a rental property into the name of the trust. Transferring stock and bond certificates, and there's a process to follow for that, where you're actually putting those stock or bond certificates into the name of the trust. Assigning personal property with a document either called a bill of sale or an assignment of personal property into the name of the trust, and then changing life insurance and retirement account beneficiary designations so that those go into the trust as well after you're gone, as opposed to going potentially to a minor, which is not what you would want to have happen. All right, well, here I have some good news. Talking about estate taxes. I mean, the bad news is that there is an estate tax out there. There's an estate tax on the federal level, and there's an estate tax on the Minnesota level. Kind of like with your income taxes, when you file income taxes, you have to file the IRS form to the federal government, and you have to file the Minnesota Department of Revenue form to the Minnesota level. And in Minnesota, we have a Minnesota estate tax. We also have a federal estate tax. But the good news that I have for you is that the exemptions for those estate taxes are really high. And what those exemptions mean is on the federal level, you don't have to worry about paying any estate taxes until your estate is valued at more than $11.7 million. And that's a number that you can actually double if you're married. You have something called portability where it doubles automatically. And so the surviving spouse of a couple gets to apply $23.4 million. It's like a coupon for $23.4 million, gets by for free out of their estate and gets to go to whoever they want to inherit it without having to pay any estate taxes. If you're above that amount, though, the estate tax can be pretty high, up to 40 cents on the dollar for every dollar above that federal exemption. And there's a little lower rate, but you get to that 40% pretty quickly above $11.7 million. In Minnesota, we also have an estate tax, and that estate tax is somewhere between 13% and 16%, but it only applies to dollars beyond $3 million. So there's a $3 million exemption in Minnesota, but you can also double that $3 million exemption if you're married, but you have to do some planning in order to do that. And the planning involves treating some assets as estate taxable at the first death, and then preserving that treatment for the second death. It's complicated, but what you have to know is if you need to double that estate tax exemption in Minnesota, if you're close to or above that $3 million, and you are married, then you really need to work with an estate planning attorney who can help you get documents in place and help you with the process after the first of you passes away so that you can double that $3 million. All right, so this is something that most estate planning attorneys won't talk about and don't really cover, but it's something that I think is really important. And it's, will your assets be lost to the State Department of Unclaimed Property? And in Minnesota, in our State Department of Unclaimed Property currently, there is $700 million sitting there. And a big part of the way that those assets get there, that money gets there, is when somebody passes away and their heirs are trying to collect all of the property that they can find, or their personal representative, whoever it is that comes after them and is responsible for collecting the assets. When they go and they try and collect all of the assets, they end up missing some things. And it's really unfortunate when that happens, because it ends up, after a certain period of inactivity going to the State Department of Unclaimed Property, it can still be pulled back from that State Department of Unclaimed Property, but it's a difficult process. There are a bunch of forms that you have to fill out, and that's assuming that somebody actually finds out that the property is there, which often doesn't happen. Often it just isn't discovered. I can tell you, as somebody who is young and still, building the inheritance for my children, I want to make sure that my children receive every dollar that I have to give them in their inheritance. And so it's really important for me that nothing be lost to the State Department of Unclaimed Property, but everything goes to my kids, who I want to receive everything if something happens to my wife and I. And so there are ways that I take care of that as an estate planning attorney, that I help my clients to ensure that nothing is lost. And having a trusted advisor who's aware of your assets, who's aware of what you have and where things are, can really go a long way to ensuring that things aren't lost. All right, so this is really cool. You can actually make your estate plan, you can make your living trust a real treasure chest for your kids or for whoever you want to inherit. And when I say that, when I talk about making it a real treasure chest, what I mean is protecting those assets from things like divorce or from things like a lawsuit in the future. And it is really cool. It's something that we can build in now to protect those assets. It's something that they can't give themselves, but you can protect their inheritance so that they're able to enjoy that money and do things with it that you would want them to do with it, as opposed to needing to pay it over in a lawsuit or to pay it over in a divorce settlement. Planning for incapacity. Now, this is something that I know is especially present for a lot of us right now. And this can mean a number of different things. It can mean planning for somebody who can make financial decisions for you if something happens to you, and when they can make those financial decisions and what kind of financial decisions they can make for you. But it can also mean making decisions about your person and about your body and about your health and the health care that you receive. And who can make those decisions for you, and what do those decisions look like? And so some people will probably recognize the person pictured here. It's Terry Schiavo. And Terry Schiavo was in a vegetative state back in the mid 2000s, and there was conflict in her family about how this should be handled. Some people in Terry's family, her husband, wanted her to have her sustenance taken away. Because he believed that Terry would never want to be stuck in this vegetative state where her interaction with the world was limited, and it wasn't clear that there was really any path back to being able to function and being able to make her own decisions in the world. Her parents, on the other hand, believed that Terry still was interacting with the world, and she was in this kind of vegetative state, but there really was possibility of working her way back and having a meaningful existence, having a functional, meaningful existence. And they thought that Terry would want to continue as long as there was that possibility. And so there was this fight between Terry's parents and Terry's husband about who should have the right to say what should happen to Terry and whether she should still receive sustenance. It led to a lot of court and a lot of conflict in the family. And it was not necessary. This is something that you can take care of. You can say exactly, this is the situation where I would want to continue receiving sustenance. This is the situation where I wouldn't. You can lay that out in a document called a living will or a healthcare directive, and you can really have the power, you can have the control to say what you want, as well as naming the healthcare agent of your choice who you know has similar views or similar thoughts to the way that you view your health and the way that you view your existence. So we've talked about a lot of things today. We've talked about the court process of probate. We've talked about guardianship for minor kids. We've talked about planning for incapacity. We just got done talking about that. We talked about estate taxes. We talked about planning so that your assets don't go to the state departments of unclaimed property, but that they go to the people that you want to receive those assets. So what can you do today to do the right thing for your family? And what should it cost to plan right? And really, if something here has resonated with you today, you probably know that you want to make a plan. And so your options really are to make a plan to do it yourself and to do something like an online will, or to work with a lawyer. And do keep in mind, not all lawyers are the same. And I'll tell you what to look for here from a lawyer in just a minute, if that's the best option for you. But first, let's address that. Should I do it myself, or should I work with an attorney? And so here's what I lay out, some considerations about whether you would benefit from working with a lawyer. If you own more than just your personal belongings, and personal belongings include things like cars, clothing, jewelry, furnishings, if your assets go beyond that, if your assets go to things like you own a home, if your assets go to substantial holdings in a bank account or an investment account, or substantial retirement savings or life insurance proceeds that you can expect to come through for your loved ones, then you would probably benefit from working with an attorney. And in particular, probate is the process that kicks in after you pass. Probate is necessary if you own real estate at your death, or if your total assets outside of real estate add up to more than $75,000. And that's things that don't pass by beneficiary designation. I'm not trying to muddy the waters here, but knowing that probate process, if you own your home, or if you have assets in excess of $75,000, you probably want to work with an attorney to make sure that you get it right and make sure that your family is able to avoid that court process called probate. And if you want to ensure that the people that you love stay out of court and conflict, and that they have a trusted advisor to turn to when something happens to you, then you've got to work with an attorney. That's the way to get that trusted advisor, is by bringing them on board while you're alive, so that they have somebody that they can turn to after you're gone. If you want a kids protection plan, which includes long-term guardianship, short-term guardianship, as well as other documents that will make sure that your kids are well cared for if something happens to you, then you have to work with an attorney. And if you want to avoid probate or estate taxes, or if you want to protect your child's inheritance with something like an asset protection trust, then you have to work with a lawyer in order to get those things done. There's just no other way to do it. If you want to guarantee that your plan is going to work when your family needs it to work, then you have to work with somebody who knows how to do these things and who has done these things and has experience working in this area, and that's working with an estate planning attorney. And I just want to say on that last point, I'm a huge do-it-yourselfer generally. That I like to do projects on my own. I like to build IKEA furniture and all that kind of stuff. And there was this situation recently where, and it wasn't so recently, it was over a year and a half ago, but I was putting fishing line on my son and my rod and reel, and we were going to go fishing together. And the fishing reel had shipped to the house without any line on it. So I had ordered some fishing line separate. But I did something wrong as I was putting that fishing line on this rod and reel. And I don't know exactly what it was, if it was coming off of the spool wrong, or if I just put too much on the reel. Whatever it was, when I got done, all of a sudden that line started jumping off of the reel. After I had cut the line from the spool, it started jumping off of the reel, and it created this giant tangled mess of fishing line. Now, it was frustrating, right? It was a do-it-yourself project that had gone wrong, but a couple of saving graces. Number one, I knew immediately that it had gone wrong. And I knew I had immediate feedback that what I had done with that rod and reel was not the right thing, clearly, to do. Number two, the cost wasn't big for me to fix my mistake. I had a little bit of extra time that I had to work in order to get things untangled and to get things fixed. And I was able to get everything fixed fine, so that my son and I were able to go fishing that same morning. But the fishing line as well had a small cost attached to it. I mean, it was like 20 cents a fishing line, not a big deal, right? So the time and cost that it took me to repair this problem was minimal. And that's just not the case if you're trying to do it yourself with your estate plan and something goes wrong. Number one, you're not going to know that things didn't work out. Your family is going to know that things didn't work out the way that you wanted it to, but they're not going to know until you're gone and until it's too late to fix the issue. And number two, it is costly. It is going to take energy. It's going to take time. It's going to take money to fix any mistakes from your estate plan. And again, this is after you're gone. It's something that your family is going to have to be dealing with. And it's something that your family is going to be dealing with when really they should be able to devote their attention and to devote their time and energy into mourning you, into grieving the loss of you in the family. And when they can't do that, it can lead to conflict. It can lead to issues within the family, and even sometimes having the family dissolve or break apart because of that conflict. That's not something that you want. I know that's not something that you want. It's not something that I want. It's something that I want to make sure to avoid. And that's why it can be so important to work with an estate planning attorney, somebody who knows what they're doing, rather than trying to do it yourself when it comes to your estate plan. One other point, if you want your assets to go to someone other than your kids, maybe you don't have kids, maybe your kids haven't been present in your life for a long time. Or maybe you just want to bypass your kids and you want to go directly to the grandkids. In any of those situations, if you don't want your kids to receive, they're the natural people to receive. If you don't want that to happen, then you really need to work with an attorney to make sure that your distribution provisions are written in the correct way and that they're honored. Now, I want to revisit this quote that I gave you earlier. Someone asked to graduate at the bottom of the class, and again say this was not about me. This was about another estate planning attorney who really underserved my family in working with my grandmother before she passed away. And again, I don't think it was about this attorney's knowledge. I think it was about the model that this attorney was practicing under. And again, I call it planning for death because the typical experience, that's all that they're planning for. You're going to get form documents where they'll fill in your name and maybe fill in your address here and there. But there's not a lot of customization, and they're not bringing you along on the process in order to make the decisions and to make sure that you are empowered in making your own decisions and that you completely understand the instructions that you're writing for the people who are coming after you. So you're just getting these form documents that are kind of set it, forget it. And oftentimes you'll get those documents, you won't really understand them, but you'll figure, I think it's done. I think this is good enough. The lawyer told me that this was good enough. You're going to put it in your drawer and you're going to kind of forget about it. And in that situation, those documents may work for you in the future, but probably not. They probably aren't going to serve your family in the way that you want your family to be served. And it's a really unfortunate thing, but that's pretty typical in estate planning right now. Typical experience also isn't going to keep money out of the hands of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys are focused on. It's not something that they're working on and avoiding. And I know that, again, I don't want the State Department of Unclaimed Property to end up with any of the assets that I want going to my kids. Typical experience may avoid probate, but may not. In fact, a lot of estate planning attorneys end up just planning for probate, and they just write a will, plan for probate, and sometimes it's because they know that that probate is going to come back to them, and that they're going to have the money for planning the estate on the front end, and then they're going to have the money for handling the probate for the family on the back end. And it's an unfortunate thing, but it is true that that unfortunately that's how a lot of estate planning attorneys operate. I don't think that serves clients, and so that's not what I do with my clients. I want to keep my clients out of probate, and I think that's the best way to serve them and to serve their families. Typical experience probably doesn't keep family out of conflict. If things are going into probate in particular, there can be a lot of conflict in the family about how things are being handled and about how mom or dad would have wanted things to be handled. And it can lead to a lot of conflict. Typical experience is only going to focus on money. It doesn't focus on things like stories and values, your intangible assets that I think are crucial. And there's something that I capture in a process called a family wealth legacy interview that is part of a third meeting that we do together. And we record that and capture that for the people that you love. And I think it's so important. Those intangible assets oftentimes are the things that we treasure even more, much more, in fact, than any inheritance that we receive from people who pass away, or from people that we're connected with who pass away. The typical experience is going to leave assets to heirs unprotected without that asset protection from things like divorce and things like lawsuits. Typical experience, you're not going to have ongoing legal guidance. You're not going to have a relationship with that attorney in most instances, and in particular because most estate planning is very transactional, and it is based on paying hourly fees for these transactional documents. And so you're not really building up a relationship with that attorney. You're not building a relationship where your family can go to that attorney and feel like they can get guidance in the future, because any future needs, there are going to be hourly fees for those future needs. And that's something that just is destined to make a plan fail, is not having future guidance, not having future follow-up, is something that makes your plan much less likely to succeed. Typical experience is not going to adequately protect the kids. That maybe there will be that long-term guardianship who's going to raise them until the age of 18, but it's going to miss that short-term guardianship, who can be there with the kids, who can take the kids instead of child protective services. And you're really going to be left with this question: is this plan going to work when my family needs it to work? And that's not a question that you should have ever after working with an estate planning attorney, I don't think. It's not a question that my clients have because I take the time to educate them and empower them to make the decisions that that take control over their estate plan and make sure that their family is well cared for after they're gone. So planning with me is totally different. It's a very different experience. I call it planning for life. And in that process, you get to choose the flat fee package of your choice based on your budget, your finances, and what is going to take care of your family in the way that you want them to be taken care of. Planning with me means that you can keep money out of hands of the state. And we do that by creating an inventory and by working directly with me as your guide through the process so that I'm aware of where your assets are and when something happens to you, because something will eventually happen to all of us. We'll have that inventory that we can give to the people coming after you who are looking to collect everything and make sure that everything is found and is going to the people that you want it to go to. Planning with me means protecting your kids totally in the immediate short term and avoiding any kind of child protective services, as well as the long term, who's going to raise those kids until they're 18. Planning with me means keeping your family out of court and conflict. And at my heart, I really am a peacemaker. And it is so important to me that that your family is able to avoid court and conflict, again, when they should be able to be grieving you, when they should have space where they're able to grieve the loss of you. Planning with me is going to mean knowing that you've made the right decisions, because again, I want to bring you along on the process. I want to educate you. I want to empower you to make decisions and take control of the aspects of your plan that are most important to you. And that's my process, but that really distinguishes me from the form document process that most traditional estate planning attorneys follow. Planning with me, it means you can protect the family money from outsiders. That inheritance can be safe from things like divorce and things like lawsuits that might happen for the people that you want to inherit down the road. And planning with me, it means having a lifetime of guidance and protection, because you're going to have a relationship with me. It sounds weird, but we're going to have a relationship with each other where you'll be able to reach out to me and you're not going to have to fear those hourly fees for picking up the phone and calling me, or shooting me an email with a question. You're not going to have to worry about that. We're going to have a back and forth where we communicate with each other, and that's going to help ensure that your plan works the way that you want it to when it needs to. And planning with me means that your plan is going to work when your family needs it to work, and it's really a gift that you're giving to the people that you love the most. But what should it cost? Right? And I know, again, as somebody who's cost conscious, this is on many of your minds right now, that this is something that is very concerning to a lot of people. And so let me provide some context around this cost question. First and foremost, if all that you have is a house that's worth $400,000, and I recognize it's a pretty nice house, but that's just a number that I've chosen here. If all that you have is a house worth $400,000, then putting a plan in place is going to save your family at least $12,000. And that is the 3% figure of the cost of probate. The probate costs in Minnesota, we estimate somewhere between 3 to 6% of the gross value of your estate. So again, if all that you have is a house worth $400,000, 3% of that is $12,000. You can save your family that $12,000 by getting an estate plan in place that avoids probate. If you have assets over $3 million, then this planning is going to save your family at least 13 cents on the dollar, up to 16 cents on the dollar for assets in excess of $3 million. That's that Minnesota estate tax here in Minnesota. Again, that's not why most people do estate planning, but it is important to know that, and important to know that in the context of your assets if you are over $3 million. A typical estate planning attorney is going to charge at least $1,500 to do an estate plan with them. If they're charging you less than that, something strange is going on. Oftentimes you can find online do-it-yourself options for something like $100, $150, $300. But again, you should know that the cost that you're paying at that level is going to get you precisely what that cost is. It's not going to get you very much. It's not going to take care of your family in the way that you probably want them to be taken care of. And neither is this typical death plan with a lawyer of $1,500. It's probably not going to keep your family out of court and conflict. Again, a lot of times that plan means that your family is going to need to come back to that lawyer to get them through the probate process down the road, which has all those additional costs attached to it. It's probably not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. That's just not something that most traditional estate planning attorneys deal with or think about or take care of. It's only going to cover your money. It's not going to cover your kids' immediate care, nor your values, insights, stories, and experience, those most valuable intangible assets that are also the most often lost assets. On the other hand, you could plan with me. I'm a personal family lawyer, and that means that I work really directly with you and I work really directly with your family to make sure that the plan is going to work when your family needs it to work. And planning with me, it means that you get to choose your own fee based on your budget, ranging somewhere between $2,000 and $8,000. And most people fall right in the middle. They fall somewhere like something like $4,000, $5,000 for most of the plans that I do. They're in that range. And so there you go. You have a very direct answer to the question, what does it cost to plan with you? Generally, it's something like $4,000 to $6,000, $4,000 to $5,000, but it depends on what you want and it depends on what you choose in our session together. And again, it is your choice. I will give you the positives and negatives for the decisions that you're making, but I will always honor your right to make that decision. That's something that is crucial and non-negotiable for me. And I want to make this really easy for you. I want to make the next step that you take very easy for you. And I want to do that by giving you our one-on-one meeting for absolutely free. And I value that meeting at $750 because it's 2 hours of my time in that meeting, just in that meeting alone, not including prep time, where we are going to be meeting with each other and talking with each other about everything that you have and everyone that you love and exactly what would happen in your specific situation if something happened to you. And so we're going to talk in the first hour. It's really educational and it's talking in the specifics about your situation and what would happen and what things you might want to be thinking about or that might concern you. Maybe it's a concern for you, maybe it's not. If we talk in that first hour and it turns out that the plan that's already in place, whether you have a plan in place or if it's the state's plan for you that's in place, whatever that plan is, if that is already ideal for you, or if it's good enough for you that it doesn't make sense to go on and continue and complete a complete plan, that's fine with me. I am going to be really happy with the knowledge that I was able to educate you and talk to you about the specifics of what is going to happen in your situation. And you can walk away after that hour knowing that that what you want to have happen is already going to happen, or you're okay with what's going to happen. On the other hand, if you want to continue and actually design your plan, again, I'm going to educate and empower you through that process and help you to take control and make the decisions about what your plan is going to be so that you completely understand your plan and that you're able to get that plan custom designed to you. And so that's what the family wealth planning session looks like. Again, the first hour is that educational component where we talk about everything. We talk about the things that you have and the people that you love. And the second component is where we actually get to design your plan if you want to continue and design your plan. It is a no obligation meeting. But again, I value it at $750 because it's 2 hours of my time that I want to give you for free. And I want to give you it for free if you will take the time and do a little bit of homework ahead of time. And I promise it's nothing onerous, but I really want you to schedule that plan with me. I also want to give you $250 towards the plan of your choice if you will reserve your appointment before the end of the week. And by the end of the week, I mean 5 o'clock on Saturday. If you will just get that appointment on the books, scheduled, that's the next step. And it is so important that you continue the momentum because estate planning, getting an estate plan in place is really a momentum thing. And right now you have the momentum going in the right direction. You've taken the time to be here with me and to educate yourself on this topic. And so I want you to continue that energy. I want you to continue on and get your estate plan in place so that the people that you love are taken care of when you can't be there to take care of them. So the next steps are, and I'm going to go ahead and post my booking link here in the chat box right now, is to schedule that family wealth planning session with me. And I want you to click over it. I want you to click through that link If you're watching this on YouTube, you might find it down in the description below or in the comments below. But I want you to click through to that link and take a look at my calendar. And you can see times for a family wealth planning session on there. I want you to click in and see what's available. I can tell you I don't have any times left this month. I book out quite far in advance because I only take a select number of appointments each month in order to ensure that I can work very closely with the clients that I have. It takes a lot of time and it takes a lot of energy and it takes a lot of my attention in order to make sure that my clients are well and properly served. And so I limit the number of clients that I take on each month. Again, you can see I'm probably booked into the next month, if not the month after that. But I want you to get this on the books right now. And again, in order to incentivize you, in order to make sure that you're taking that next step and keeping the momentum moving without too much follow-up and too much pursuing from me, I want you to have $250 towards the plan of your choice that you can use if it makes sense to continue and do a plan with me. And I really think that it does. So I hope that you right now are clicking through and taking care and getting scheduled with me. I really am looking forward to meeting with you. I'm looking forward to having time with you and getting to learn about your specific experience and about how I can help you. I am going to go ahead and end the presentation now. I don't see any questions coming through. But I want to thank you for being here with me today. And I want to thank you again for taking the time to educate yourself. This is so important, and you're going to be happy that you did. All right, take care, everyone. Bye.